Good morning. My name is Hae-Sun Kim, advisor of Gangnam Labor Law Firm. Today, with the labor attorney Jung Bong-soo, we will discuss about the case of recovery of infringed managerial rights through collective bargaining. I understand that Gangnam Labor Law Firm has provided collective advice to the Seoul metropolitan city. So could you explain about this particular right?
Okay. Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. So this is the case I represented the Seoul city government as a chief negotiator with the civilian workers working for Seoul city. So they have a very strong labor union. So the labor union has a collective agreement. In this agreement, there are a lot of infringed the articles about the management right. So, for example, when company introduce a new regulation, they must obtain the consultation or agreement with the labor union. Also, when they introduce a new new technology or new work some method, then they must obtain some prior consultation with the labor union. Also, other items they could not operate a business without consultation with the union in advance. So it is a kind of infringing the managerial right. So as a chief negotiator for Seoul city government, I negotiate with the labor union, and finally we cancelled those. Actually, we get rid of those some infringed managerial right. So, such as some disciplinary process, also like prior consultation or prior consent with the union regarding about the managerial right. So, because of this one, I could get some good recommendation, or I think how I achieved this managerial right. That is, while we are negotiating with the union, we proposed the Seoul city government's new draft for collective agreement. Then union rejected, so then they went to strike in front of Seoul City Hall. Then, but at the time, Seoul mayor didn't she was very strict about his determination to protect the managerial rights. So in this process, how I could achieve is because the collective agreement has a fixed term. So in order to cancel the previous one, we have to inform, we have to report, notify the termination of current collective agreement. Then this means then after 6 months they received this notice from the Seoul city. Then the current collective agreement could not be available anymore. So I used this process. Then union knew their collective agreement would disappear because it has a fixed period. So because of our strategy, the union accepted, and we start to negotiate again for some new draft from Seoul city government. Then finally we got rid of those infringed items like managerial rights. So thanks to my effort and Seoul city's support, we could obtain the managerial right, discover managerial right from infringed articles. So such as when they introduced a new regulation, then our proposal was we listened to their opinion, not to have some prior consultation. Also, when we Seoul City government tried to hire the irregular workers. At that time, previously, prior consultation required, but our revision is we listen to their opinion from labor union. So something like that, we abolished about 6 items that infringed the managerial right. So finally, labor union successfully, they accepted our draft, even though they were a little bit revised. But in total, like generally, we discovered some our infringed legal right. So it was very successful negotiation. Yeah.
I see. I think Gangnam Labor Law Firm provided this advisory service when the manager right was not so strong to be protected. So in case of the amendment to reach to the final agreement, what are the major amendments do you remember that you can introduce?
Yeah, I think when they take a disciplinary action, so they they need to collect they need to invite 5 people the representing union and also some Seoul City government. So there are 5 some disciplinary action members. So whenever they have a disciplinary action, they must compose those numbers. But sometimes it depends on the types of disciplinary action. So it is some long process. So how we divided is 5 people. The 2 people representing union, 3 people representing Seoul City government. So it's so complicated. So what it changed is the disciplinary action members must be 3. They are appointed by Seoul City government. So previous one so complicated, but after changing this rule, it became easier and more operational, more acceptable by the Seoul City government. So this is some very typical item I devised through some negotiation with the labor union. Yeah.
I see. Based on your long-term experience with the Seoul City government, I think, and this video can be very educative to those future collective agreement when you face.
Yes, yeah, thank you. I think so. This lesson, really, this experience has taught me it can be applicable to any new the collective agreement, collective bargaining process with the new union, because the reason is many companies they have such infringed items of managerial right, such as without unions agreement they cannot fire people, or they cannot hire the regular the temporary workers. Even some companies without agreement union they cannot have overtime work. So it is very strict violation of managerial rights. So I think labor unions, their role is very important to protect job security. But at the same time, if their environment is more than required, then it will cause a lot of disturbance or kind of very disturb the normal operation of the company. So my role is try to abolish those infringed item of managerial right. So I'm strongly think that the collective agreement should be fair to the employee. I mean union members, also companies. So those infringed right infringed the managerial right, it could cause a lot of negative operation for companies. Yeah.
I see. Thank you very much for your comment for recovering the managerial right.
Okay, thank you for watching. Bye bye.